And good morning, everyone. This is John Neerman. It is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, June 10th, 2020. The time is 9:30 a.m. And I'll begin with a roll call. Commissioner Lindley, are you on the line? Commissioner Lindley, is your phone on mute, perhaps? Are you there? How about Commissioner Janeka? Are you on the line?
Present and accounted for.
Hey, good morning. How are you?
Just fine, thank you.
Commissioner Lindley, have you been able to join? Well, we have a quorum. We'll check back for Commissioner Lindley in a moment. Ms. Smith, are you there?
I am here.
And how about our Public Interest Counsel? Mr. McWhorter, are you on the line?
Good morning, Chairman. I'm here.
Good morning. Since we're holding this meeting over a conference line, I'd like to remind folks to keep their phones on mute when they're not speaking. And I'd also like to remind anyone who is here only to listen that they can watch the meeting online. And that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please email agenda@tcq.texas.gov with your name, your affiliation, and the item that you'd like to comment on, and we will do our best to accommodate that request. For those of you who are making presentations, please wait to begin your presentation until I or our general counsel have asked you to begin speaking. And again, please make sure that your line is unmuted before you proceed. With that, Commissioner Lindley, have you been able to join us?
I am here, thank you.
Good morning. Ms. Smith, I think well, let me thank everyone for being present. And Ms. Smith, if you will, please go ahead and call the first item.
Item number 1 is the application by Crystal Clear Special Utility District and MCLB Land LLC for the new TPDES permit number WQ00152660002. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted as present for the record.
Thank you. For the benefit of those of you who are not familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester meets the requirements, then we consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and who have done so both in timely comments and in a hearing request are entitled to a hearing. In this case, we have a governmental entity, the city of San Marcos. So for governmental entities to be affected persons, they must also have the authority under state law over issues raised by the application. And colleagues, I'm going to recommend that we grant all 3 of these requests. It's clear that Chris Carson Select Investments, and the city of San Marcos have met the procedural and substantive requirements to be entitled to a contested case. Mr. Carson and his business own property very near the proposed facility, and that proposed facility is within the city's ETJ and in proximity to city-owned facilities. Let me turn to the issues. And again, for those who aren't familiar with our process, we refer issues that an affected person has timely raised, both in their comments and in a hearing request, and that are relevant and material to the application. Relevant and material means that the issues must be within the agency's jurisdiction on this type of application. So for example, we lack jurisdiction to consider erosion or flooding on a TPDES application such as this one. Colleagues, I'm going to propose that we refer several issues, and let me tick through them for you. The first one is whether the proposed discharge will violate TCEQ's anti-degradation policy or harm livestock or wildlife, whether surface and groundwater quality will be protected, whether the nutrient limits comply with the surface water quality standards, whether the draft permit complies with the rules for abatement and control of nuisance odors, whether the application is complete and accurate, whether there are any issues regarding the applicant's ability to comply with the permit, whether the permit is consistent with state policy on both need and regionalization as articulated in our rules, and whether the draft permit is protective of the health of nearby residents. And let me pause there and ask you, Commissioner Lindley, how you came out, if that sounded all right to you.
I'm in complete agreement with the parties you named and the issues for a silly hearing.
Thank you. I appreciate that. Commissioner Janeka, what are your thoughts?
Likewise, I agree on the effectiveness of the 3 parties who requested and also those 9 issues you identified. And in terms of duration of hearing, well, I'll stop there and let you take it. Thank you.
No, that's great. There sounds like the meat of the matter we're in agreement on. There were also some requests for rehearing that are, in my view, redundant to the hearing request, so I would deny those. And given the number of issues and that SOA is operating under burdens, I would allow the full 180 days for the hearing. And I guess at this point, I'll entertain any additional thoughts or a motion.
I can suggest a motion and see if y'all are in agreement. It sounds like we are.
Great.
I move that we grant the hearing request filed by Chris Carson Select Investments LP, and the City of San Marcos, that we deny all requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the proposed discharge will violate TCEQ's anti-degradation policy and procedures or negatively impact aquatic or terrestrial wildlife species, including livestock. B, whether the draft permit will be protective of surface water and groundwater quality. C, whether the nutrient limits in the draft permit comply with applicable Texas surface water quality standards. D, whether the draft permit complies with applicable requirements to abate and control nuisance orders as set forth in 30 TAC 309.13E. D, whether the application is complete and accurate. F, whether the applicant's compliance histories or technical capabilities raise any issues regarding the applicant's ability to comply with the material terms of the permit that warrant denying or altering the terms of the draft permit. G, whether issuance of the draft permit is contrary to the state's regionalization policy or Texas Water Code 26.0282. H, whether the Commission should deny or alter the terms and conditions of the draft permit based on the consideration of need under Texas Water Quality 26.0282. And I, whether the draft permit is protective of health of nearby residents, and that we set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
Commissioner Lindley?
Yes.
In issue number H, you said Texas Water Quality Section 26.0282, and I just wanted to clarify that you meant code.
That is correct. For my motion,
Okay.
I did Texas Water Code 26.0282. Thank you.
Thanks.
I would second that motion as clarified.
Thank you. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the application by Quail Run Services, LLC for new TPDES permit number WQ 00157111001 to authorize the treatment and discharge of domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted as present for the record.
So colleagues, again, we have a two-part analysis for considering requests for contested cases. The first part concerns who gets a hearing, and I'm going to recommend here that we grant some of these requests and deny others. I would grant the requests of Carlene and Patrick Janicek, Jonathan B. Wheat, and Michael B. Wheat. The remaining requesters, in my view, are either situated too far from the proposed facility to be affected in a manner different from the general public, or they fail to raise an issue within our jurisdiction on this application. So let me pause right there and see how y'all came out on the parties. Commissioner Lindley?
I'm in agreement with the naming of, let's see, how many is that? Those four individuals.
Okay. Commissioner Janeka?
Likewise, I'm in concurrence with that analysis.
All right, thank you. Let me turn to the issues portion of the analysis. There were several comments relating to flooding issues, which is outside our jurisdiction on this type of application, but I believe that the affected persons did raise referable issues on nuisance odor and water quality. And Commissioner Lindley, how did you see it?
I agree. I think that's a good analysis. I'm in agreement with those two issues. I guess I think
Likewise.
Okay, thank you. I appreciate that. And there were also some requests for reconsideration, but in my view, those are not based on new grounds, so I would deny them. And here again, I would allow 180 days for the hearing. And with that, I'll invite any additional comments or a motion.
I will make the motion that we grant the hearing requests of Carlene and Patrick Janicek, Jonathan B. Wheat, and Michael B. Wheat, deny all remaining hearing requests and requests for reconsideration, refer the matter to the TCQ's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts, refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code 309.13, and B, whether the draft permit is protective of water quality, including the protection of existing uses of the receiving waters, livestock, and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards, and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
And Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is consideration of material changes to contract for goods and services awarded under Chapter 2155 of the Texas Government Code, executed during the previous quarter. The Executive Director's staff is here to present the item, and if you would, please begin by stating your name for the record.
For the record, my name is Robert Apollinario, Contract Supervisor for the Procurement and Contract Section of the Financial Administration Division. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I am representing the Executive Director today. This item contains material changes made to contracts and purchases for goods and services between September 1st, 2019 through November 30th, 2019. Reported material changes include extensions to the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more. In accordance with Section 2155.088 of the Government Code, the Executive Director presents these items for your consideration. I'm available to answer any questions you may have.
Thank you. I appreciate that. I have none. Colleagues, any questions?
No questions from me. Thank you.
Likewise, no questions here. Appreciate it.
Thank you. Ms. Smith, do we have anybody signed in to speak on this matter?
No, we do not.
And Mr. McWhirter, what's the view from the Public Interest Counsel's office?
OPIC recommends approval of the resolution acknowledging material changes to contracts for goods and services as presented by the Executive Director.
Thank you. I agree. I've reviewed this item and think it's appropriate to approve the resolution. And colleagues, I'll entertain any additional thoughts or a motion.
I will move that we approve issuance of the Executive Director's proposed resolution that acknowledges the material changes to contracts for goods and services in accordance with the Texas Government Code 2155.088 for the period of September 1st, 2019 to November 30th, 2019, as described in the TCEQ Interoffice Memorandum to the Commissioners and Executive Director dated June 10th, 2020, in docket number 2020-0547-MIS.
I second that motion.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
And Commissioner Janeka, how do you vote?
Aye.
I likewise vote aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to the enforcement docket, items 4 through 48. Item 7 was remanded yesterday in response to a motion by the Executive Director. The Executive Director's staff is here to present these matters. If you would, please begin by stating your name for the record.
For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division representing the Executive Director. Pending before you are items 4 through 6 and 8 through 48. The total assessed administrative penalties are $633,887, with $109,766 deferred, $153,846 applied toward supplemental environmental projects, and $370,275 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
None from me. Thank you.
Thank you. And Ms. Smith, I understand that we have 3 people who have signed in and wish to address the Commission on our enforcement items, all signed in on item 16, which is the agreed order for the City of Liberty Hill. And I'd like to afford them 3 minutes each. Do I have my facts straight? Did I get the correct number?
That's correct. I'll also note that on items 11 and 12, we have folks who have signed in but indicated that they don't wish to speak, so their presence will be noted for the record.
Thank you. And I think we'll hear first from Daniel Morris, who has signed in on item 16. And Mr. Morris, I'll ask you to identify yourself and any affiliation you may have, and then go ahead, and we'll give you the floor for 3 minutes, sir. And Mr. Morris, if you can hear me, you might check to see if you're on mute, because we can't hear you. Mr. Morris, we still can't hear you, so why don't we check back with you and move on to the next person who's signed in, Ms. Lorraine Hone. Are you on the line, Ms. Hone?
Can you hear me?
I can hear you.
Yes.
Yes. Ms. Hone, please state your name and any affiliation for the record, and then the floor is yours for 3 minutes.
Sure. My name is Lorraine Home, and I'm an attorney with Texas Rio Grande Legal Aid, and I'm here on behalf of Stephanie Morris. So Ms. Morris is a landowner whose property abuts the South Fork San Gabriel River, about a quarter of a mile downstream from Liberty Hills wastewater outfall. We would like to draw the Commission's attention to a few issues with the enforcement order before you today. For violation 1, which regards the lack of walkways and permanent stairway, we believe the penalty is miscalculated. And the violation was listed as lasting from the investigation date through the schooling date, which is 1 quarter. The violation clearly was going on before the investigation date and continues until and past today, since it's the subject of the SET project, which is 9 more months than a quarter. Related to that is the long list of effluent limit violations and violation 4. This is going from November 16th to May 8th, 2008, sorry, November 2016 through May 2018, which is 9 months, almost all of which have at least one violation, if not more. But they only list 3 monthly events, even though these violations are chronic, ongoing, and often underreported. Then for the violations involving discharges and sludge, like 3, 5, and 8, we urge the Commission to reconsider the minor and moderate actual harm assigned to these. Our client has been told not to go in the river by a TCEQ staff member on a normal day. This is a low-flow stream where people regularly recreate. And the river doesn't reflect the reality on the ground, which is actually a high degree of actual harm. We are glad to see that there are some technical requirements, such as inspection and cleaning of solids and algae. However, we know specifics about how far down the river they need to clean, how far across, what they should do. And the solids tend to migrate downstream, and the algae goes past my client's house, and generally downstream for over a mile, sometimes farther. So clearly the outfall is insufficient. And we are glad to see that there's going to be an engineering report with corrective actions taken to help fix the nutrient issues with the city's wastewater. We would like to impress upon the Commission that the permit limits for nutrients like phosphorus and nitrogen are far too high, and so that either reducing or limiting the discharges whether are really cranking down the nutrient content of that wastewater. This will not remedy the degradation in the stream. Thank you for your time.
Thank you, Ms. Owen, for your comments. I appreciate that. Let's check back with Mr. Morris. Are you on the line, sir? Mr. Morris, are you with us? All right. Moving on. Ms. Carol Hawkins, are you on the line? Ms. Hawkins, can you hear me? You want to check to make sure you're not on mute if you can hear me? Well, my technology is simultaneously frustrating and I'm marveling at it, because even though we can't hear Ms. Hawkins' voice, I'm looking at a photograph that she's provided to us. Commissioner Lindley, do you have that up? Are you able to see the photograph?
Let me see here. I don't.
And while you're checking, Commissioner Janeka.
I do see it now. Yes. Yeah.
Okay. So you're looking at it. Commissioner Janeka, are you looking at it?
I am.
Okay. Assuming that this is the segment that perhaps Ms. Hone was referring to. So let's give Ms. Hawkins maybe just another moment. All right. Why don't we move on? And before we consider any motion on the slate of enforcement items, but let me offer just a couple of responses to Ms. Hone. Ms. Hone, as you may know, and really for the benefit of anyone who's interested in a matter that's on our enforcement docket, and especially on the we are very happy to hear from the public on these agreed orders. It's somewhat challenging to get comments on the cusp of an action. The agreed orders are published in the Texas Register for the purpose of receiving comment from the public, and if the commission gets written comments ahead of time based on the Texas Register notice, we're in a much better position to react and respond to those. And then substantively, I appreciate that that this order may not achieve all of the goals or desires that we might have for the water body. It nevertheless will ensure that a significant amount of money goes to improving the operations of this particular facility. And so I would still be in favor of approving this agreed order. And let me give my colleagues a chance to offer any comments, and then we'll check back to see if Mr. Morris or Ms. Hawkins have been able to join. Commissioner Lindley, any thoughts?
Excuse me. I'm in agreement with everything you said. I do appreciate all three individuals signing in and Ms. Hone's comments today. I think what's before us today, I'm comfortable with adopting, and so I wouldn't propose any changes to the agreed order.
And Commissioner Janeka, any thoughts?
Likewise, I think I would love to make sure that we've heard all the public testimony, but I think that this is this was a matter that was screened in accordance with the agency's policies, and I think that the significant costs of this compliance step and all required for work to be completed at this facility, part of which should help improve future compliance. I think there's a good reason for moving forward on the agreed order. I'm not sure that I'm not sure I see an alternative path. So I would be more comfortable moving forward today, right now, rather than requiring further consideration of it.
Why don't we flag all those comments as provisional until we've exhausted our efforts to get Mr. Morris and Ms. Hawkins on the line. And let me ask again if Mr. Morris or Ms. Hawkins are able to hear me. We will keep trying, but let's hear next from Public Interest Counsel. Mr. McWhorter?
Yes, Chairman, I agree with all of the comments that each of you have made. My office reviewed this item, and we would recommend approval of the proposed order.
Thank you. And any comments on the broader docket of enforcement items that are before us?
Yes, sir. We reviewed all of the items, all the enforcement orders, and we recommend approval for the orders on your docket today.
Thank you. And for Ms. Cordell or any staff member, do you have any further comments or responses to at least Ms. Hone's remarks?
Yes, Chairman, this is Brian Sinclair. Can you hear me?
I can, thank you.
Okay, thank you. We did look at just at the DMR, the effluent data for City of Liberty Hill in the last year, and while there are some exceedances of ammonia nitrogen in May of 2019 and excuse me, in April of 2019 and February of 2020, they were not at a high enough level to trigger any sort of enforcement response. There were also some E. coli or bacteria exceedances in January and March of 2020, but again, not high enough to trigger enforcement, and as well as phosphorus in September of 2019. So generally, the wastewater treatment plant is producing effluent that they're reporting that's generally compliant, and the exceedances aren't at a high enough level to trigger enforcement.
Thank you, Mr. Sinclair. I appreciate that. I think, Commissioner Lindley, Commissioner Janeka, that we have heard everybody who's been able to be heard so far.
Except for me.
Oh, Ms. Hawkins, is that you?
Yes.
Wonderful.
Thank
you. Yeah, thank you. Okay, I'm glad you're on. I know technology can be nerve-wracking, but your photos are up. I can tell you that.
I actually could see the photos. I don't know what the problem with muting is. I'm here to tell you those photos are the way that river looks most of the year these days.
Mm-hmm.
I have relatives who live. Yes.
And Ms. Hawkins, I'm sorry, let me interrupt you. Why don't we start with having you state your name and any affiliation that you have for the record, and then I'll just give you the floor for 3 minutes.
Sure. I'm Carol Hawkins. My affiliation is that I have family who lives on the river, and so I have been intimately acquainted with the river for the past 7 years, and the way the river has degraded since the city of Liberty Hill has been discharging their sewage into it regularly has been disgusting. And the pictures that you see are the way that river looks most of the year. Most of the year. Recently, an interesting thing happened in that my relative had a conversation with somebody in the septic tank industry who told them that they have a friend who works in the Liberty Hill sewage treatment plant. And he said, do not let anybody in your family go into that river ever under any circumstances. And my relative said, why? And he said, even if the water doesn't look very bad, you should know that the attitude of the sewage treatment plant is that they are not going to follow the rules, that they expect that they'll be discharging untreated effluent into the river regularly, and that they will just follow that with a very strong chlorine, which we know they're not supposed to do either one of those things. And that the fines that TCEQ imposes are so low that they really don't care. And so my relative said, are you just talking about little turds like when you fart, you know? And he said, no, look at the bottom of your septic tank. We're talking untreated, thick, sticky, brown muck, like I would pump out of your septic tank, and they're just going to, quote, clean it with their chlorine. And, you know, we're talking the stuff that they see in the river regularly is large brown solids. They smell sewage, chlorine. I've smelled this too. And the algae problems are humongous. These pictures that you see here were taken a half a mile south of the treatment plant, and the river is like that almost all the time. And the algae stretches across the river, and when you step into it, you see the pictures. That's not anything you want anybody getting into. And my relatives have seen people putting babies in baby carriers right at that pretty little waterfall where the outflow is. There's no sign. People are not warned that this river is toxic. Thanks, Liberty Hill. I got to stay. What? Interesting. How can I help you?
Sorry, folks. I violated my own rule and I had myself on mute. I want to thank Ms. Hawkins for her comments and say that I appreciate all the commenters taking the time to share their experiences about the river and their concerns about it. Whatever the facts on the ground may be, and I'm not intimately knowledge. Don't have intimate knowledge of it or firsthand knowledge of it, but whatever the facts on the ground are, I think that this agreed order more moves us towards improving those water bodies. So, in light of the comments that we've heard, I still think it's proper to move forward on this. Commissioner Lindley, any additional thoughts?
I'm in agreement. I do appreciate the pictures and the comments, and I just want to note, I guess, that what's in the agreed order today, at least in my understanding, and if I have any that's wrong, the executive director or someone else could correct me, that the engineering report is required to figure out what's going on with the plant, but it also requires them to fix the problem, and it requires them to assess the receiving stream on a weekly basis. So folks might already know that, but I just wanted to state it out there in case they didn't, just so they're aware of, some of the stuff we're agreeing to today. So with that, I'm still in agreement with you, Chairman, in adopting all the enforcement doc in front of us today, with the exception of item 7.
Thank you. Commissioner Janeka, any thoughts?
I think Commissioner Lindley put it very well. I was just reviewing that draft agreed order myself, and I am encouraged to say, and I would encourage Ms. Hawkins and the other commenters today, as well as other concerned individuals, to look at this order because the city will be required to comply with this and expected to hold to it just as they are their permit. And I think this matter is before us today in no small part due to complaints that drove this process, and I appreciate that. I'm glad to see the process worked. I'm always eager to find opportunities where we can try to work more quickly and more responsibly to ensure that the public's concerns are being addressed timely, and I think this is an instance of concerns being remedied at the speed of governance. The state is never as fast as I would like it to be. However, the provisions that Commissioner Lindley pointed out, the requirement to monitor the outfall weekly for algae mats, the quality of the outfall, there's a requirement of an engineering evaluation of the facility to determine the cause and corrective actions for that discharge of any wastewater sludge or nutrient-rich wastewater. So I'm sensitive to anecdotal evidence of bad operators, and Ms. Hawkins, the reports that you've heard through family members are always concerning, certainly, but I think our agency is quick to respond to those complaints. So I would encourage you and your families and those residents along this river to continue to watch, and please keep us, our regional staff, informed if there are continuing concerns in the future. But I'm confident that our agency will be able to deal with this as they have consistently with all other matters of borderline or noncompliance. But I do appreciate your testimony today.
Commissioner Janeka, thank you for those remarks. Let's give Mr. Morris one more opportunity to offer his thoughts if he's on the line. Mr. Morris, have you been able to join us? All right, colleagues, I think we need to move forward here. If there are no final thoughts, I'll entertain a motion on the enforcement items.
I will make a motion that we adopt items 4 through 6 and 8 through 48 as recommended today by the executive director.
Commissioner Lindley, was that a second? I got a little interference there.
It was, yeah, I think we're on at the same time, but I did second.
Thank you. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 49 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present this item.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division and Charmaine Backins of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2020 through April. There are 1,003 effective administrative orders issued, and of those, 125 contain supplemental environmental projects. These orders assessed a total of $10,570,141 in penalties, with a payable amount of $6,221,625. $2,623,616 are to be paid towards supplemental environmental projects. 11,375 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,201 enforcement action referrals have been received. There are 1,592 pending administrative orders with 149 cases that are on the backlog. 207 cases are pending at the Attorney General's Office for representation in district court, and 9 judgments have been issued. 2,016 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2018, 19, and 20. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley?
No questions. Thank you, Melissa.
And Commissioner Janeka?
No questions for me. I appreciate the report.
And Public Interest Counsel, what are your thoughts?
I don't have any questions either, and I appreciate the report.
Thank you. Thank you, Ms. Cordell. I appreciate the report, and no action is necessary on this item. So, Ms. Smith, please call item 50.
Item number 50 is the consideration of the adoption of the repeal and simultaneous adoption of new 30 Texas Administrative Code Section 7.117, the Memorandum of Understanding between the TCEQ and the Railroad Commission of Texas. The Executive Director's staff is here to present this item, and as you begin, please state your name for the record.
Good morning. This is Kathy Humphreys with the Environmental Law Division. With me today is Diane Goss, also of the Environmental Law Division, and Lori Fleet of the Water Quality Division. This rulemaking repeals 30 TAC Section 7.117, which adopts by reference the Memorandum of Understanding between the Railroad Commission of Texas and the Texas Commission on Environmental Quality, found at 16 Texas Administrative Code Section 3.30, and adopts the full text of the Memorandum of Understanding between the Railroad Commission and the TCEQ at new 30 TAC Section 7.117. The new section includes changes regarding the transfer of responsibilities relating to certain oil and gas discharges from the Railroad Commission to the TCEQ, and the dual authorization of Class 2 and Class 5 injection wells. TCEQ's proposed rules were published in the February 28, 2020 issue of the Texas Register. The TCEQ held stakeholder meetings on September 17, 2019 and December 11, 2019, relating to the implementation of HB 2771, including discussions of this rulemaking project. The TCEQ will continue to hold quarterly stakeholder meetings regarding implementation of HB 2771 until completion. No stakeholder meetings were held on HB 2230. However, on August 16, 2016, a public hearing was held on Rule Project Number 2016-021-331-WS, which partially implemented HB 2230. The public comment period on the proposed rule closed on March 30th, 2020. We received comments from the Sierra Club. The Sierra Club is generally supportive of the MOU between the Railroad Commission and TCEQ, as well as the rulemaking, but recommended changes regarding enforcement and handling of complaints. Responses to Sierra Club's comments were developed and are included in the backup material before you today. No changes were made to the rule in response to public comments. The Railroad Commission proposed the rulemaking to implement the Memorandum of Understanding on February 11, 2020, and is scheduled to consider the adoption of the proposed amendments to the Memorandum of Understanding at its open meeting on June 16, 2020. Staff respectfully recommends adoption of this rulemaking. Staff also requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Ms. Humphreys. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
No questions from me. I appreciate, I'm glad to see that we did get some comments on it, and I appreciate staff's response to those comments. I think it's appropriate across the board. Thank you.
Thank you. Ms. Smith, is there anyone signed in to speak on this item?
No, no one is registered to address the commission.
And Mr. McWhorter, what are your thoughts?
OPIC recommends adoption of this rulemaking implementing House Bill 2230 and House Bill 2771 as presented by the Executive Director.
Thank you. And colleagues, this MOU is really to conform to certain jurisdictional changes the legislature has made between TCEQ and the Railroad Commission, including, as we heard, with respect to produced water discharge and injection of brine from desalination facilities. I appreciate the work that went into it with the Railroad Commission staff as well as our staff, and want to thank them for that. And I think it looks good, and I'm ready to move forward. I'll entertain any additional thoughts or emotion.
I'm in agreement. It's been a lot of work for our staff and staff of the Railroad Commission. Appreciate all the hard work that went into it. And with that, I move that we adopt the repeal of 30 Texas Administrative Code, Section 7.117, and simultaneous adoption of new Section 7.117 as recommended by the Executive Director.
I second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 51 is the consideration of the adoption of new sections 328.200 through 328.204 of 30 Texas Administrative Code, Chapter 328, regarding waste minimization and recycling. The Executive Director's staff is here to present this item, and if you would, please begin by stating your name for the record.
This is Kalen Room. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Kalen Room with the External Relations Division. With me is Kathy Humphreys with the Environmental Law Division. This adopted rulemaking will implement portions of Senate Bill 1376 from the 86th Texas Legislature relating to governmental entity recycling and the purchasing of recycled materials. Chapter 328, new subchapter K, documents the requirement for governmental entities to establish a program for the separation and collection of recyclable materials generated by the entity, establish that governmental entities shall give a preference in purchasing for products made of recyclable materials, and provide for exemptions from the requirements. The proposed rules were published in the January 31st, 2020 issue of the Texas Register. A public hearing was held on February 27, 2020. The public comment period closed on March 3rd, 2020. The rule team received public comments, and based on those comments, the rule team made the following substantive changes. Revised the proposed section 328.204 to provide consistency with Texas Government Code section 2155.445, which states that the preference for the purchasing of products made of recycled materials will be given if the product meets applicable specifications as to quantity and quality, and the average price of the product is not more than 10% greater than the price of comparable non-recycled products. Additionally, the 6-month Texas Register filing deadline noted in the executive summary was revised to July 31st, 2020, based on the 6-month time frame in Texas Government Code, section 2001.027. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 328. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you. We're available to answer any questions.
Thank you, Mr. Room. And there was some interest in the staff, some interest by the staff of reordering the rule for clarity, but there were some perceived notice limitations to this. Is that correct? If you know, or maybe perhaps Ms. Humstreet. Okay. I don't have any additional questions for you at this time, colleagues. I do want to address that, and I'll offer some thoughts on that in a moment. But in the meantime, Commissioner Lindley, do you have any questions for Mr. Room?
No questions. Thank you.
And Commissioner Janeka?
No questions. I'd like to commend staff on taking a pretty narrow reference of our agency in a broader education rulemaking on an interesting topic of procurement, and I'm glad to see we're putting this in the rule now, and I think it appropriately seeks to implement that statutory direction.
Thank you, Commissioner. Ms. Smith, is there anyone signed in to speak on this item?
No one's signed in on this one.
Thank you. And Mr. McWhorter, what are your thoughts?
OPIC supports the addition of new subchapter K to the Commission's Chapter 328 rules to delineate governmental entity requirements for recycling and purchasing of recycled materials. Rulemaking implements portions of Senate Bill 1376, and OPIC recommends adoption of the rulemaking as presented by the Executive Director.
I do too. I agree. I think we should move forward with this. My only hesitation, as I noted a minute ago, is that staff wanted to, again, reorder the rule for clarity, but had some concerns that that would not be properly noticed. And our Office of General Counsel has the same concerns. The idea that there could be a notice issue with simply reordering for clarity seems hyper-technical to me, but I'm sure there's a good reason for it, and I trust the expertise of our staff and OGC on this. So, colleagues, I'm going to propose that we move forward with this adoption, but also instruct the Executive Director to reopen the rule to reorder sections 328.203 and section 328.204 for clarity. Those sections refer to exemptions and the purchasing preference in that order. Those instructions would simply be from the dais and would not need to be made part of any order or motion on this rulemaking. So, Commissioner Lindley, what do you think about that plan?
I think I'm fine with that. I guess at the end of the day, that we still move forward with adopting everything as is. You're just kind of doing what we wanted done in the process, but weren't able to get done. Isn't that maybe the way to say it from the desk?
Exactly. I mean, what we'll be doing is moving forward with this rulemaking. It will be in and done, but then going back to simply to make the rule more clear and more user-friendly, which I think is important every opportunity we have, because all of our rules are difficult. So let's strive for clarity and make that happen where we can do it. But that would be add-on, a second effort, just as directed from us in the dais and not part of an order. Just to confirm your understanding, Commissioner Janeka, what are your thoughts?
I'm certainly in agreement, and I think I now understand what your suggestion is, that it will be instructions from the dais just to address this in a future rulemaking, or catch it on the next circle around. Good. Yeah, I'm inclined to follow your lead. You've got the expertise of the three of us in terms of assessing that legal risk from our staff. So perfectly comfortable moving forward as you propose.
Great, thank you. So with those instructions to go forward with a future rulemaking to provide that clarity in the rule, let's act on what's before us, and I'd like to hear a motion to adopt this rulemaking.
I would move that we adopt new sections 328.200 through 328.204 of 30 Texas Administrative Code, Chapter 328, Waste Minimization and Recycling, as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
We three are unanimous. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 52 is consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 114, to implement House Bill 1346 and House Bill 1627. The Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Amatio Gutierrez with the Air Grants Division. With me is Sierra Redding with the Environmental Law Division. This rulemaking amends Chapter 114, Control of Air Pollution from Motor Vehicles, Mobile Source Incentive Programs, Diesel Emission Reduction Incentive Program for on-road and non-road vehicles, subsection 114.622 and 114.629. as amended by House Bill 1346 and 1627. If adopted, the amendments will be submitted to the Environmental Protection Agency as revisions to the state implementation plan. The proposed rules were published in the January 31st, 2020 issue of the Texas Register. A public hearing was held on February 25th, 2020. The public comment period closed on March 3rd, 2020. The rule team did not receive any comments during the comment period. In conclusion, staff respectfully recommends adoption of this rulemaking for Chapter 114. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Mr. Gutierrez. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
No questions for me.
Ms. Smith, has anyone signed in?
No one has signed in on this one.
And Mr. McWhorter, what are your thoughts?
OPIC recommends adoption of the amended sections of the Commission's Chapter 114 rules and corresponding revisions to the state implementation plan to implement House Bill 1346 and House Bill 1627 as presented by the Executive Director.
Thank you. I agree. This is an implementation, again, of a pair of relatively minor legislative changes to our TURP program. There were no comments, and I think we should move forward. I'm happy to entertain any additional thoughts or emotion.
I move that we adopt the amendments to 30 Texas Administrative Code, Chapter 114, and corresponding revisions to the state implementation plan as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 53 is the adoption of the 2015 8-hour ozone National Ambient Air Quality Standard Emissions Inventory State Implementation Plan revision for the Houston, Galveston, Brazoria, and Dallas-Fort Worth and Bexar County non-attainment areas. The Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Mary Ann Cook of the Air Quality Division. I am joined by Amy Browning and Terry Salem of the Environmental Law Division. For your consideration today is the Executive Director's revision to the State Implementation Plan, or SIP, to address the baseline emissions inventory, emissions statement, and non-attainment new source review SIP requirements for the Houston, Galveston, Brazoria, Dallas-Fort Worth, and Bexar County non-attainment areas under a marginal classification for the 2015 8-hour ozone standard. Staff respectfully request adoption of this SIP revision. Thank you for your consideration, and we are available to answer any questions.
Thank you, Ms. Cook. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None for me, thanks.
Ms. Smith, has anyone signed in to speak on this item?
No one signed in on this one.
And Mr. McWhorter, what are your thoughts?
OPIC recommends adoption of the 2015 8-hour ozone national ambient air quality standards emissions inventory state implementation plan revision for the specified non-attainment areas as presented by the executive director.
Thank you. I agree. And colleagues, I'll invite any additional thoughts you may have or a motion at this point. I think it's appropriate to move forward.
No thoughts or comments from me other than just to say I do appreciate the comments from the public on this item. I understand there's always strong arguments for regional players and individual stakeholders to argue for individual decisions in what years. I think the staff really took the appropriate approach in line with EPA's decisions and guidance. So I'm comfortable making the motion that we approve the adoption of the 2015 8-hour ozone national ambient air quality standard emissions inventory state implementation plan revision for the Houston, Galveston, Brazoria, Dallas, Fort Worth, and Bexar County non-attainment areas as recommended by the executive director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. And Ms. Smith, when you're ready, please call the next item.
Item number 54 is our public comment session. And no one is currently signed in on this item or registered to speak, but we will unmute the webinar for a moment and give anyone on the line a chance to let us know if they would like to address the commission.
And I guess let me remind folks, if there's anyone who's trying to offer comments, just double check your phone, make sure it's not muted. I suspect that perhaps there's nobody who wishes to make comments at this point.
So,
Ms. Smith, perhaps we should go ahead.
Yeah, I was going to say, hearing no one, I would recommend that we mute the line again and move on to the next item.
Yeah, please go ahead, Ms. Smith.
Items 55 through 58 are for closed session, and the commission will not meet in closed session today.
Time is 10:32, and we are adjourned.
Thank you.
Thanks.